Welcome to meeting number 73, the House of Commons Standing Committee on Justice and Human Rights. Pursuant to order adopted by the House on March 22nd, 2023, the committee is meeting in public to continue its study of Bill S-224, an act to amend the Criminal Code, trafficking in persons. Today's meeting is taking place in hybrid format pursuant to the House Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. I'd like to take a few moments for the benefit of the witnesses. Actually, I'll pass. I think you guys are all well experienced, and so is Mr. Caputo and the analysts online, so I think we're good to pass on instructions on Zoom. I welcome the officials from the Justice Department who will help us by answering technical questions about this bill and the amendments. So today we have with us Natalie Levman, Senior Counsel, Criminal Law Policy Section, and we also have Ellen Wiltsey-Brown, Counsel Criminal Law Policy Section. So welcome to both of you. When ready to start clause by clause, I'd like to provide members of the committee with some reminders on the clause by clause process. Members should note that new amendments must be submitted in writing to the clerk of the committee. During debate on amendments, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing. They do not require the approval of the mover of the amendment. You all have received the agenda and the amendments package again yesterday. Let's now proceed with the clause by clause study of the bill. I will now call clause one. I did call. I got a good drum roll. Clause one, block amendment one. I think it's 12547306.
Oui, Monsieur le Président. Alors, merci.
Yes, thank you, Chair. We're quite in agreement with the spirit of this bill, but it seems a little bit incomplete in its current form. We're proposing some amendments which I think you've received, and we'd be quite comfortable in voting in favor of Bill S-224 in dealing with Clause 1B, for example. It says any other similar act. That seems a little bit broad, and we'd like to flesh that out a bit. This would be acts by which take advantage of other persons' vulnerability. Somebody who's accused of having exploited someone. We should try to say not only it was similar acts to those mentioned, but also that they took advantage of the person's vulnerability. I would also say that in Clause 2, we would like to modify that and amend it. It eliminates everything else that was in subsection of the Act. So we'd like to insert the factor of fear, let's say, in determining when an accused exploiting another person under subsection 1, the court may consider, among other factors, whether the victim, A, that they fear for their safety of a person known to them, and B, is able to give informed consent considering their age or other personal circumstances, such as financial situation or mental condition. So the vulnerable individual perhaps is too young to provide informed consent and would be at the mercy of the person who is actually exploiting them. They would be under the control of the exploiter. So before finding anyone guilty of such a serious crime, we should in fact be precise in obtaining the evidence, and the evidence should be available. So this is the amendment we'd like to propose. Thank you, Chair.
Has his hand up? Mr. Caputo, can you hear me?
I'm sorry, Chair, are you referring to me? You just cut out there for a
Yes,
moment.
you have your hand up. Just referring if you would like to speak.
Can you hear me? Okay, I can't hear anybody there, unfortunately, right now here. Just say yes. Okay, oh, sorry, I got it all taken care of. Sorry. My fault. You can all hear me, and I'm sitting here fumbling like an idiot. Okay, I got it now. Okay, thank you very much. I have a question here, and I'd love for the our legal experts to weigh in. My understanding from hearing from the witnesses on this is that this is a crime that can be quite insidious in that oftentimes people don't even know that they're being trafficked. That is the nature of the crime itself. The manipulation is so substantial, and the nature of the victimization is such that a person doesn't even realize that they're being taken advantage of. And one of the reasons that convictions are so difficult in this type of crime is because the person may not even have actual fear, or they are themselves afraid to testify as to actual fear. So while I can stomach easily the first part, and that is sub B in clause 1, I do have some issues with sub 2A, because to me it seems to go against what the witnesses told us. So I'm curious to hear from the analysts about their opinions on this, because again, it seems as though this doesn't require the court to do so, but because it's there, they're likely to consider it. And I'd like to hear from Mr. Fortin on that point. Thank you.
Merci, Monsieur le Président. Et merci, Monsieur Caputo.
Thank you, Chair, and thank you, Mr. Caputo. Well, I'm concerned by the aspect that you point out. Yes, it's true that an individual who's being exploited may not be quite aware of it for various reasons. But 2B, I think, covers that situation. An accused who cannot offer an informed consent considering their age or other personal circumstances, such as their financial situation or mental condition. So if the person is not conscious of the fact that being exploited, they're unaware of it, due to their particular individual circumstances, would be covered by 2B. And the exploiter would be found guilty of the crime of which he's being accused. A victim, in the sense of a victim, if she were to consent, informed consent, the behavior that's being tasked to the exploiter or the accused, well, any crime, to be a crime, of this nature, needs to have an aggressor and a victim. If there's no victim, there's no crime. So if the victim cannot offer informed consent because she's unaware of the circumstances or is caught in another situation, be a silent witness. So 2B covers Mr. Caputo's concern, I believe, and provides a bit more information for the prosecution. Someone may have a valid defense. If there was an agreement between two individuals based on informed consent, well, we may not find the behavior very acceptable, but if they agreed, they agreed.
I don't know if the analysts were asked to give the witnesses were asked to give their answer on that, or Mr. Caputo had asked, I think.
You refer to the analysts, we just make sure
Oh.
it's not to the...
Mr. Caputo, your question, was it to the witnesses or to the analysts?
It was to both. I don't mind chiming in here at this point, though, just to reflect on what Mr. Fortin mentioned, and then maybe I can have the analysts weigh in. See, what I find difficult, and I understand Mr. Fortin's rationale, but it seems to be unduly complicating the matter, because the whole point is that this is trust, power, and authority or an act by which you're taking advantage of another person's vulnerability. That's his amendment. If the person, the inherent in all of this is the person's vulnerability, which is confirmed by B, but then A seems to run counter to that, I just don't know why, we really need either of them, because the whole point is the vulnerability being taken advantage of. To me, those two things seem to cancel each other out, but I would like to hear from the legal experts on this point, please.
Thank you, Chair. I do have a comment to make on both 2A and B, but I thought I would just back up so that I could make sure we're all on the same page. My reading of this amendment is that it would still replace the existing legal test, the existing definition for exploitation, with the one proposed by S224, which focuses on causing another person to provide labor or services through certain specific illicit means. And the blocks amendment would further specify what other similar act means in terms of taking advantage of another person's vulnerability. And then sub 2 is more like an interpretive clause, so there are factors, as I understand it, that a court could consider when determining whether or not that legal test is met in subsection 1. The first factor is whether or not the victim fears for their safety or the safety of a person known to them. While that is a little bit similar to the existing test in 279.04 sub 1, it differs because it's entirely subjective, whereas the current legal test in 279.04 sub 1 is an objective test, and we know that from appellate case law. It wouldn't determine whether or not the legal test was met, but it would be something that a court could factor in, as would paragraph 2B. And this is the one that causes me a little bit of consternation because it refers to consent, and I'd like to bring the committee's attention to what is currently in subsections 279.012 and 279.0112. No consent to the activity that forms the subject matter of a charge under subsection 1 is valid. And that is consistent with what the previous speaker said, which is where these illicit means are used. The law says that it doesn't matter whether someone gave what courts call an apparent yes. The coercive practices used amount to human trafficking. So I would just point that out to you as a legal and technical matter and a potential inconsistency between 2B and existing subsections 279.012 and 0112. Thank you.
Thank you. Mr. Garrison and then Mr. Van Popta.
Thank you very much, Mr. Chair. And I hope you give me a little bit of latitude because it's hard to talk about the amendments without talking about the bill as a whole. So we heard from, I guess, two different perspectives from witnesses. And one of those I found very persuasive. And that was that this bill doesn't actually do anything which would make the struggle against trafficking more effective, that it won't actually provide more resources for targeted trafficking units in law enforcement. It won't actually provide more resources for those who are fleeing trafficking situations in the community. And those who've worked with trafficking issues know that those are the two most important things that we could do to help combat trafficking. And in casting a broad net, as the original bill does, we risk making the mistake that we've been warned again in all our discussions about sex work, is that when you define something too broadly, you capture a lot of things that ought not be captured. And I think S224 defines trafficking in such a way that many practices which are not in fact trafficking will get included under the bill. And the danger there is when you make everything trafficking, you miss the real trafficking, and you miss the most serious parts of the trafficking offenses. And so for that reason, I can't see that S224 is a useful bill. I understand Mr. Fortin's attempt to fix those problems. I think it's a goodwill attempt that he's put forward here in these amendments. My problem at this point is that I know that I've received a petition signed by more than 60 organizations asking us not to proceed with this bill, and they have not been consulted on anything being suggested by Mr. Fortan. And so I would be hesitant to vote for these kind of amendments without hearing from witnesses on the specifics of this. And I think we would be better off as a committee defeating the amendments because we haven't had input on the specifics of them, and then defeating the bill or recommending that the House not proceed with the bill in the future. So for that reason, Mr. Fortan, even though I think it's a very good effort to fix the bill, I won't be supporting your amendment, and I won't be supporting the bill. Thank you.
Thank you. Mr. Van Popta?
Thank you. My question is for Ms. Levman. You made reference to appellate jurisprudence. I don't know if you're referring to the Marcus Sinclair case, which is from the Ontario Court of Appeal. And it said that the test is an objective one. I'll just read one sentence. The assessment here was an objective one. Could the appellant's conduct be reasonably expected to cause the complainant to believe that her safety was threatened? Which is, we had witnesses tell us that too. So how would the Blocks Amendment change that? You're saying that it would become more of a subjective test. Would that have made a difference in the outcome of the Sinclair decision, which I think confirmed the conviction?
So yes, that is one of the appellate cases, but there are a number of them, and now not just in Ontario, but also one in Quebec and in BC, and they all follow the Sinclair reasoning, so we know that it is an objective test. But the difference between what's in the code now and what is proposed by S224, including with the Block's proposed amendment, is that the bill would change the legal test. The legal test, the test that would need to be proved, would no longer be whether or not a reasonable person in the victim's circumstances would believe that their physical or psychological safety would be threatened if they failed to do what was being asked of them. The legal test would be whether or not the accused caused the victim to provide their labor or services through one of the illicit means, one or other of the illicit means. Now, the sub 2 section in the Block's amendment is an interpretive provision. It's not a legal test. So in determining whether or not that legal test would be met, were it law, the court would then look at whether or not the victim subjectively feared for their safety. At least that is the way that I'm reading this amendment. And the fear for safety in the Block's amendment is different from what is currently in Section 279.041, which is an entirely objective test, meaning that the Crown does not have to prove that the victim in that particular case actually experienced fear. Here, that would be required, and the judge would consider whether or not the victim experienced fear, and then I assume if the judge were to find that, or the jury, that the victim did experience fear, that would weigh in favor of the legal test being met.
Let me continue. That would make it so. That would require the victim then to give evidence as to her or his state of mind. Correct? Because, and I understand that under the current legislation and certainly under the Bill S224, without amendments, would not require the victim to come to court to give evidence as to his or her state of mind.
Well, that's true of the law right now. The appellate case law is quite clear that proof of actual fear isn't necessary. And in fact, paragraph 15 of the Sinclair decision goes over a number of different factors that the courts ought to consider when determining whether or not the existing legal test is met. But certainly in the world of S224 plus the block amendment, what the court would need to hear is whether or not the victims subjectively feared for their safety. That's how I read the blocks amendment, yes.
So thank you.
Yes.
I vote against.
No other, any comments? No? Shall block 1 carry?
It's a point of order, Mr. Chair.
point of order.
I think Ms. Briard just stepped out
Oh,
For-
okay. I'll just wait.
with the member's indulgence.
Yeah.
Well, it is an observation and potentially a point of order.
We'll give her the
Are
courtesy.
we okay with a two-minute recess?
I'll just suspend for 2 minutes. We'll resume. Not to put Miss Briard on the spot, but it's okay. So shall block 1 carry? You want to do it on? No. Yeah, record it. No. No? Doesn't carry? Okay.
I don't, yeah.
Shall clause 1 carry?
No.
No.
No. Okay. Doesn't carry? Shall the title carry?
No.
No, so the title doesn't carry. Now this one just giving you go ahead.
I mean, maybe I wasn't able to ascertain whether, on that last one, whether it carried or didn't carry, just based on the voices. Maybe we have a recorded
It's head,
vote.
so it
Oh,
did.
you saw, all
Yes.
right. Yeah, all right, no, that's fine.
Shall so
do
this one, I just want to be clear, even though we didn't have the clause carry, I do have to say shall the bill carry and take it back, so I just want to be careful. Voting yes, shall the bill carry doesn't mean you voted yes for the amendment. So shall the bill as amended carry?
You have to take it to the,
Okay,
just hold, Gary.
Sorry, Mr. Chair, can I just
Sure,
get
you want
clarification,
clarity
please?
on that?
So we're on the third vote or the fourth vote?
the title didn't carry, we're on the 4th one,
Okay,
which is
sorry,
shall the
yes.
bill.
So the standing orders means you have to take it back. So yes.
Yes,
Oh, it hasn't? Okay, I was just,
no amendment.
it was amended. Yeah.
Was it amended?
So shall the
We deleted the
bill
clause they're
as
saying.
amended carry?
Can the clerk explain the process, please, or somebody?
Sure, we can have
Or
a
the
clerk.
legislative or somebody, because we're a bit confused.
It's an unusual situation, so I'll let the clerk clarify.
Thank you, Mr. Chair. Yes, indeed, the bill was amended by removing clause 1.
Okay.
Hence the question.
Yes. And by the standing orders, we have to report it back to the House anyway.
Yes, you do.
Okay. Yeah. Hold on,
Shall-
Mr. Garrison.
Mr. Garrison?
So that means when we're reporting back to the empty bill,
Correct.
just so
With it-
everybody's clear.
Yeah.
So,
Okay, let me get this right. There's two options for this. So if we say shall the bill as amended carry, it goes back as an empty shell. And then it's in the House. The other one, we could have a motion that the committee recommends that the bill not proceed, correct? And then we can vote it that way. So I will go with the first just because it's already written here and it's a little easier for me. So. And I don't want to get into any challenges. So shall the bill as amended carry? Yes. Okay, carried. Shall. So
So that's too
it's
late.
a shall.
We're voting.
So it's a shall, so it's sent back with no clause. Yeah, it won't even have a title. Because we said yeah.
Come on.
So shall the chair report the bill as amended to the House? Yes, okay. Okay, that ends that part. Just any committee business before we, yes, Mr. Garrison and Mr.
thank you very much, Mr. Chair. I'd like to move the following motion, and if the motion is adopted, also move that the committee rise and report it back to the House as a report. And that motion is the following. It has, the clerk has copies for, I think most everybody has it in both languages. That given the rising tide of hate and violence directed toward the 2S LGBTQI plus community at home and around the world, the House of Commons calls on leaders at all levels of government in Canada to speak out, to speak out strongly in favor of Canadian values of equality and inclusion for the 2S LGBTQI plus community. B, to deplore all disruptions of lawful public activities, including pride events and all children's sport and educational activities. And C, to condemn all attempts to disrupt democratic institutions, including school boards, when dealing with policies concerning equality and inclusion. And if I can, Mr. Chair, I would speak briefly to the motion.
Okay, so I would need unanimous consent because it was under 48 hours. Do we have unanimous consent? No. Okay. Yes, Mr. Nunzio.
So I believe we're in committee business, so I'm not aware that it's the 48 hours is there when all members are here, and this is being brought forward from the floor. So I would request that you reconsider that.
We can always give notice.
Yes.
Discuss later.
Unfortunately, I've consulted with the clerk. If we don't have 48 hours, we cannot proceed unless we have unanimous consent.
So can we ask for a recorded vote?
Unanimous consent.
Yeah.
Consent, that's not how it
Can't
works.
bypass that.
Mr. Garrison?
So, the text of this motion was shared with all parties more than 48 hours ago, but I realize that maybe not all members had seen this. This is the motion that the Conservatives shouted down on the floor of the House of Commons earlier today. It deals with very urgent matters in this country. In 1 hour, my staff were able to identify 18 incidents in this country in the last 3 months of attacks on children's activities by protesters against equality and inclusion. And so it's very timely for us to be able to deal with this. There is no substantive piece here that contradicts any party's public stance. What we're asking is for leadership from Canadians in elected governments at all levels to stand up for inclusion and equality and against hate. So I would ask again for the Conservatives to consider whether they would let the vote on this motion go forward today, given the urgency of what's happening in our communities. We had a story just come out yesterday about transgender folks in Winnipeg who are receiving regular death threats and are working with the police to stop those death threats. So this is why this leadership is so important. We could have a long debate about why this is happening in our country, but it's something deplorable and it's something new in the level of its intensity. And for me, the fact that it targets children is what makes it completely unacceptable. And so I would urge the Conservatives to reconsider their denying consent for this go forward. If not, it will be notice of motion, and I would ask it be the first item on our agenda when we come back in the fall.
Since there's no change from the membership, I will look into that, I guess, the subcommittee when we come back, and we will look at that. I want to thank everyone for a great session. We've been a very proactive and committee. We've done a lot of reports, I think record amount of reports a lot of committees have done, so I really want to thank you for working very cooperatively. I want to thank our analysts, our clerks, our interpreters, our officials that have come and given us a lot of help, all the staff in the backgrounds, all the sound staff back here. Hopefully you have a great and excellent summer. I think Irina is going to be gone to a different committee, so but we will miss her, and maybe we'll sneak her back. And yeah, we'll try to vote her back in. You got it. So thank you very much. And Mr. Danziger, you want to say something before? No?
Yeah, I just want to echo your comments, Mr. Chair, and want to thank everyone, including colleagues here. And we've generally worked very collaboratively over the last session, and we look forward to the same relationship going forward. I want to thank the clerk, the analyst, all the technical folks, all of our staff for their support, and of course yourself, Mr. Chair. I know you've handled yourself exceptionally well, and we thank you for your leadership here.
Thank you, and thank you, everyone. Have a safe summer, and we're adjourned.